Had an interesting start to my life, and it was when I was 19. I joined the United States Army. I served in Vietnam. I was trained as a Special Forces aid man, but I was assigned to the 101st Airborne Division, the Rakkasans, who had great fame at Hamburger Hill. And so I had that to start my life, and then I came to this community in 1970. I've been here ever since. That helped me get a job in medicine at Southern Nevada Memorial Hospital, now UMC. I went to law school, got my law license, and in 1985 I was selected Nevada's first domestic relations referee, which I think most people consider was the beginning of the family court. The family court arrived in 1992, and I was Department A of that court. I was elected in 1992. I served in that position until I became Mesquite's full-time city attorney in 1998. Upon retirement, June 30th of that year, I was recalled to service by the Supreme Court the next week after July 4th, and I've served about three-quarter time since then in the family court, in Clark County mostly, although all over generally. I have one unique aspect to my life other than my military service, and I think that's I am now sitting as a judge and have been a senior district judge for 5 years, doing all of the courtroom duties that a judge in this court does. I understand this court, I work in it every day. I've seen the value of mediation and peaceful resolution of disputes so that we can keep the relationship between the parties as non-hostile as possible. And so recently I've been assigned as a settlement judge in a program that lasted 5 weeks, and we had a 75% success rate, Judge Thompson and I, who is my dear colleague. I am ready to do this job full-time again. Frankly, I'm anxious to do it. I have a pretty good amount of institutional knowledge, and I'm ready to let that grow even further by coming back to the board.
I guess I'll start right here with you, and then we'll work our way down. I'm just going to ask a couple basic questions, and then you all can answer the same question. Makes it easy. One of the things is, I know Judge Elliott believes in post-divorce counseling strongly. I know that she recommends a lot of her hostile parents to have post-divorce counseling. What are your views of post-divorce counseling, and do you think in certain situations it should be mandatory? And if there are difficult situations, on who to give custody to because the situation is so hostile, do you take the child's perspective into consideration? And I don't know the rules around that, how old the child has to be, so I might be a bit naive in that area, so if you can just give me some feedback.
This is Shel Mercer. I would like to make sure that I address all of your questions. I have strong feelings about this. It's a great question. I personally believe in counseling for everybody. I think it's very, very helpful to have a teachable spirit and to understand more about yourself and to be able to receive information about yourself so that you could better utilize it in your life and especially in the family. So I believe in it personally. However, I also believe that if a person doesn't agree with me that it would be beneficial, that if they're not receptive to it themselves, I believe it'll be completely useless. I don't believe that you can order someone to undergo counseling and expect a very good reception to that unless that person is already inclined to have faith in the counseling process. Although if one were to order counseling on somebody who is just midway not really sure how they feel about it, and some of it were able to stick and they were able to learn some things and improve the communication going on with the children and with the former spouse, then so be it. So I guess what I'm saying is I favor it, but don't favor it. It would depend on the circumstances, I think, and I would, as the judge, I would want to make sure that I have parties that are receptive, at least somewhat receptive to it, so that they don't go in there, cross their hands, and just stare at their watch the whole time and wait until the hour's over, go back in front of the judge and say, I tried it, didn't work for me. Oh, there was another portion. I knew I was going to forget another.
For listening to the children.
Oh, yes. I wanted to answer your question about what the law says. Yes, the child's preference can be considered and should be considered as one of the factors when a judge is trying to decide for custody preferences of the child when the child is of a sufficient maturity. The child, there's not a certain age, there's no magical age like a lot of people believe. It's funny, I hear a lot of people saying, well, it's when they're 13 or when they're 14 or whenever. No, it's when the child is of sufficient maturity level to be able to express a preference and be able to explain properly why that is a preference. Then yes, you can consider it. But I also, as the judge, recognize that a 13 or 14-year-old doesn't necessarily know what's best for the child. It is something I would absolutely take into consideration, and I think it is an important consideration. I'd want to know why that child prefers dad over mom. Is it maybe because there's no rules at dad, or maybe there's no discipline at mom's? Whatever their reasoning, I would want to know that, because I believe boundaries and rules and discipline are essential components for growing the child and making sure that the child is being brought up well and learning well. I have so much more to say about this, but I'll let my colleagues also respond to your question. Thank you.
This is John Jensen. This is an interesting issue, and Judge Ellie and I have been friends for a long time. We discuss these issues all the time. One of the critical problems we have in Clark County is resources and the finances of the individuals that appear before us. I'm a firm believer in the more of these kinds of things you can have in a case, the better the resolution is going to be, the better the success rate is going to be. People need to work these things out for themselves. And they need to be informed to do that. Sometimes it takes somebody to lead them and guide them through the process, whether it's a counselor, mediator, or somebody giving them some sort of education, like our co-class or our family mediation, working out child parenting plans. Unfortunately, as Shell mentioned, sometimes they're unwilling to do that, and many times it's the cost of doing that for these people. Children probably are the key issue for all of these cases, if you have children involved in a divorce case. We haven't been able to do as much child interviewing as we'd obviously like to do. Some of the judges do that on their own. They have other individuals do it. Sometimes in critical situations it's done by our Family Mediation Center. Unfortunately, my experience on the bench is that you often get a different story from both parents about what the desires of the children are. And whenever it's possible, I think it is a good thing to do to have some independent person interview the child, find out what the child really thinks in a non-pressured setting where the parents aren't necessarily trying to guide or prompt or put pressure on the child to make those kinds of statements, so the court can make a wise decision. Unfortunately, my experience has been looking at real life, and unlike everybody on the panel, we all have a substantial amount of life experience, is whatever we do in court probably isn't going to work out there 100% when these people get out and they've got their decree. And the more that you can involve the people in the decision-making process and take into account the feelings and the family structure and the relationship between the parties, the better success they're going to have. But most of the time, you're going to find that these things have to be adjusted by the people who are actually involved in the family setting. And the more help you can give them, the better chance they're going to have of being able to co-parent these children as parents, and children cope with the stresses and strains of being in separate families now.